Renters' rights day on the 1st of May is fast approaching, but did you know that you need to serve this document, the information sheet, to your existing tenants by the end of May 2026? Otherwise, you might receive a civil penalty of up to £7,000. Why is this? Well, it's because the way that we let to tenants is changing fundamentally when the Renters' Rights Act comes into force on the 1st of May. And landlords have a legal obligation to make sure that the official information sheet is served on their tenants. And in this video, I go through the ins and outs of it, so you'll understand exactly what you need to do and don't need to do. Who am I? I'm Suzanne Smith, a former corporate solicitor turned landlord and the author of this best-selling book, The Good Landlord Handbook, which explains how we need to operate in the renters' rights world. I also run the Independent Landlord website and this YouTube channel to bring reliable, practical information to everyone in the private rented sector that benefits from my legal brain. You can find all the links I mentioned in the video in the caption below. Right. First of all, what is this information sheet? Well, the information sheet is an official 4-page document produced by the government, which you need to download from the government website. And I'll put a link underneath the video. The information sheet explains to your tenants how the Renters' Rights Act will change your assured short-hold tenancy automatically on the 1st of May and turn it into an assured periodic tenancy. That's a rolling tenancy. For instance, it goes through the end of fixed terms and how landlords need to use the Section 13 process if they want to increase the rent using the new Form 4A, which they've now also published. It also says that the tenants can challenge the rent in the first-tier tribunal. It also explains that no new Section 21 notices can be given from the 1st of May. Instead, landlords will need to have a reason known as a Section 8 ground, and the information sheet gives a few examples. It also explains that these rules have been introduced by law, they're compulsory, and that landlords cannot put anything into a tenancy agreement to change or disapply them. And if you do, it's just null and void. So how do landlords need to serve the information sheet on their tenants? Well, the government guidance says that you must first download the information sheet from their page, and you can see the link below. You must give the exact PDF found at the top of the page on the government website. Don't change it or try to brand it. It needs to be this exact PDF. And you must provide this to your tenants either by printing a hard copy and posting it to them or giving it to them by hand, sending the PDF electronically as an attachment, for example, an attachment to an email or a text message. But you'll see that the government says that we must not email or text a link to the PDF to the tenant, as that won't be valid. It actually has to be the PDF itself. If your tenancy agreement doesn't allow service by email, it's probably safest to send it by hard copy. Print it off for them and then post it from the post office with a certificate of posting. You can send it to them electronically as a backup. And lots of people have asked me if we need to have a new agreement with tenants, because that's something that happened in Wales, that they needed new occupation contracts. Well, the answer here is no. We don't have to make any changes to the tenancy agreement. Just keep a record of how you've served the information sheet and any acknowledgement that you get from the tenants. But if you don't have a written agreement or anything in writing about the tenancy in place, and so in other words, it's just a purely oral agreement, you've said to them you're happy to move in and give them the keys and that's it, then you'll need to serve what's called a written statement of terms. But what happens if you use letting agents for property management? Well, it's still your responsibility as a landlord to make sure it's done. But if you use an agent for property management, they're obliged to serve it on your behalf, even if you've already done it. I think the government has made this rule to make it clear to letting agents that they have to send it to tenants, and the tenants of every property that they manage. So what about for new tenancies from the 1st of May? It's important that you don't use old assured short hold tenancy agreements from the 1st of May, because all new tenancies from the 1st of May must not be for a fixed term, and they must contain compulsory items and information, either in the tenancy agreement or in a separate document. And I go through this in this video on the new compulsory terms for tenancies. If you keep using your old agreement or homebrew something yourself, you might not comply with the new rules for the assured periodic tenancies, and you could get a civil penalty of up to £7,000 for each breach. So there are a lot of new rules coming into effect on 1st of May, and despite the politicians saying it's simpler regulation,
but the bill will also ensure that good landlords enjoy simpler regulation.
It's not simpler regulation. I put a lot of videos on YouTube to explain the rules, but an easy way of getting your head around it all is to buy this best-selling book, The Good Landlord Handbook, Succeed as a Landlord under the Renters' Rights Act. It is possible. You can click the link under the video to buy it direct from me, or you can buy it from Amazon. But if you'd like to ask me questions, then you'll need to join my membership, the Independent Landlord Hub. You can find out more information here, theindependentlandlord.com/hub. And see you soon, and hopefully in the hub.